Servient property owners aren't supposed to interfere with someone's right to use an easement on his or her property. In Mueller versus Hoblyn, we'll explore ways to terminate an easement. Herbert and Glenys Engelman owned a large tract of land with access to a public highway via a private road. In 1963, they conveyed a parcel to REB Incorporated. In the deed, the Engelmans also conveyed the corporation and its successors an easement to use the private road to access the highway. However, the deed didn't specify the road's location. The Engelmans then transferred the Servient property, subject to the easement, to Henry and Jean Mueller. Through subsequent conveyances, a portion of REB's dominant land was conveyed to Lawrence Coffey and another portion to Richard and Gary Hoblyn. The dominant owners used a dirt road to access the property, which sometimes couldn't be accessed in winter. In 1977, Mueller drilled a well, fenced it in, and farmed on his property. 13 years later, Coffey had the land surveyed and discovered the easement wasn't the path he and the Hoblyns had been using. Instead, the easement actually ran through the area with the well and fencing. Mueller refused the dominant owner's access, claiming that they abandoned the easement and that he reclaimed it through adverse possession. The Hoblyns and Coffey sued Mueller in Wyoming District Court to quiet title. The district court found that the well only terminated a 200-foot portion of the easement through adverse possession. Both the dominant estates and Mueller appealed to the Wyoming Supreme Court.